Hi everyone, welcome back to Hands-Free Studying for the MBE, brought to you by Brainscape. These upcoming evidence questions cover the presentation of evidence. All right, let's get started. Question 1. The federal rules of evidence apply to what type of proceedings? All civil and criminal proceedings in federal courts. Question 2. Do the common law rules of evidence apply on the MBE? No, only the federal rules of evidence apply on the MBE. Question 3. When do the federal rules of evidence not apply? The federal rules of evidence don't apply in 7 scenarios. The first is when you're determining preliminary questions of fact regarding the admissibility of evidence. 2, during grand jury proceedings. 3, in preliminary examinations in a criminal case. 4, for sentencing, probation, and bail hearings. 5, in summary contempt proceedings. 6, for the issuance of warrants and criminal summons. And lastly, 7, in extradition or rendition proceedings. Question 4. In regards to evidence, what does the judge decide? The judge decides preliminary questions about the competency of the evidence and whether evidence is admissible, witnesses are qualified, and whether privilege exists. Note, except for deciding whether privilege exists, remember that the judge is not bound by the federal rules of evidence when deciding preliminary questions. Question 5. When does a preliminary hearing on the evidence need to occur outside the presence of a jury? If, first, the hearing involves the admissibility of a confession. 2, the defendant in a criminal case is a witness or so requests. Or 3, if justice so requires. Question 6. In regards to evidence, what does the jury decide? The jury looks at the weight and credibility of the evidence. Question 7. Under what circumstances can an evidentiary ruling be challenged? The ruling can be challenged if it affects a substantial right of the party. Question 8. What are motions in limine? Motions in limine are pre-trial motions seeking to exclude certain pieces of evidence. Question 9. If a party believes that evidence was erroneously admitted, how can the issue be preserved for appeal? The party must, on the record, timely object or move to strike, and state the specific ground for the objection, unless it was apparent from the context. Question 10. If a party believes that evidence was erroneously excluded, how can the issue be preserved for appeal? The party must make an offer of proof, which is an explanation on the record as to why the evidence is relevant and should be admitted, unless the substance was apparent from the context. And that's the end of your 10 flashcard study round. To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. Of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.